Yeah, we are live. Anubhya. Friends, I, Vivek Agarwal, convener of ACA Study Circle, welcome you on this hot topic in IBC. And we have none other than the national film Ashish Makhija ji with us. And before we proceed, let's start with the ICI motto.
येष सुप्तेषु जागृति येष सुप्तेषु जागृति कामं कामं पुरुषो निर्विमाणः तदेव शुक्रं तद्ब्रह्म तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्वैता
Thank you, everyone. Friends, I, Vivek Agarwal, convener of ACA Study Circle, welcome everyone in this hot topic in IBC. And without further delay, we all are waiting to listen to Ashish Makhija ji. I'll hand over to our chairman of the IBC committee, Sumit Binani ji. And I'm muting everyone for the security reason and for so that there is no disturbance. If you have any question, you can raise your hands or write in the chat box. Over to Sumit ji.
सुमित जी काइंडली अनम्यूट योरसेल्फ सुमित जी को अनम्यूट करो
He can unmute himself. He's a co-host.
Yeah, I'm on unmute now. Thank you, Vivek, and I welcome all of you on behalf of the Association of the Corporate Advisors and Executives. It's a great initiative from the President of the ACA, C. Anup Sanghai, and all the other office bearers to basically organize this first program on pre-pack insolvency at Kolkata. And I also thank Mr. Jitendra Lohia, who's the past president of ACA, for providing all the support to get in touch with the speaker of our day and organize this program. Well, friends, with this welcome note, I just want to brief you because Ashish ji is here and he's one of the most sought after speakers in the country as far as this particular space is concerned. And all of us have got the highest of regards for him. He has been training us whenever he wanted to become insolvency professionals, and have also been providing his insights through his regular discourse on the subjects at various forums. But yes, just to brief you, because before he takes over, we are all aware that the Insolvency and Bankruptcy Code Amendment Ordinance 2021 was promulgated by the President on 4th of this particular month for providing pre-packaged resolution framework for micro, small and medium enterprises. This amendment for pre-pack for MSMEs, in my opinion, is expected to have multiple benefits to the MSME sector, which would basically lead to time and cost effective insolvency resolution for them. It would also lead to minimum business disruption and value maximization, and also preservation of employment, and lessen burden of the National Company Law Tribunal as far as the resolution of these MSME is concerned. Pre-pack for MSME, the way it has been structured in our country appears to be a hybrid corporate rescue process, which blends elements and virtues of both the formal and informal insolvency proceedings. A resolution plan in this process is likely to be negotiated between the debtor and its creditors before the commencement of the formal proceedings, which is quite unlike the present era. And this initiative, in my humble opinion, is based on a trust model. And the amendments to this code basically honor the honest MSME owners by trying to ensure that the resolution happens and the company remains with them. So yes, the word honest is the word to be looked into. And it is expected that the incorporation of pre-patched insolvency resolution process will alleviate the distress in the MSME faced by the MSMEs due to the impact of pandemic and the unique nature of their business. So this is all enshrined in the the preamble to the amendment ordinance, and I'm sure that when you hear Dr. Ashish, I think will be more educated. And today only in the morning, the rules and regulations have been notified. So I'm sure that this is going to be a very interesting session, and we'll all come out with more wisdom. So I welcome Mr. Ashish once again to our association, and request Vivek to take forward the proceedings.
Thank you, Sumit ji. I would request R.M. Modi ji, our co-chairman, to introduce the speaker.
Thank you, Vivek ji. Thank you, this August Institution Association of Corporate Advisors and Executives, for giving me this opportunity to introduce none other than a very illustrious speaker, a very amazing personality, Sri Ashish Makhija ji. Mr. Ashish Makhija is a leading practitioner in insolvency and the corporate law matters. As managing attorney of AMC Law Firm, a firm headquartered in New Delhi, he bears top credentials in the corporate law, insolvency and bankruptcy law, corporate litigations, and advisory. He was the standing counsel for the official liquidator attached to the High Court of Delhi for 6 years, handling many large-scale cases of corporate insolvency and liquidation. He regularly appears before Supreme Court, High Courts, ANCLATE, NCLT in insolvency matters. AMC Law Firms has been detained by interim resolution professionals, liquidators appointed under IBC, Committee of Creditors, Promoters for handling processes during the corporate insolvency resolution process, liquidation, legal matters, legal advisory, forensic audit, among others. Academically brilliant, Mr. Ashish Makhija was awarded gold medal by CBSE for obtaining 100% marks in mathematics. He has been a rank holder throughout. He ranked 3rd in secondary school examination, 18th in the CA final examination, 1st rank in LLB examination from Delhi University, and magna cum laude in LLM from USA. Mr. Ashish Makhija is a fellow member of Institute of Chartered Accountants of India, FCA, and also a fellow member of the Institute of Cost Accountants of India, FCMA. He holds 2 Masters of Law degree, one from India and Master of Law degree in International Bankruptcy from USA. He is also an insolvency professional. He is pursuing PhD in law from Emory School of Law, Atlanta, USA. He has a distinction of being World Bank trained corporate trainer. He is a much sought after faculty and has spoken extensively on subjects of professional interest, including independence of directors, insolvency and the bankruptcy code, corporate laws, corporate governance, forensic audit, etc. He is adjunct faculty for Indian Institute of Corporate Affairs under Ministry of Corporate Affairs, Government of India. He has also served as the adjunct professor at Thomas Jefferson School of Law, San Diego, California, USA in 2013-14. Mr. Ashish Makhija has 14 books to his credit on the subject of insolvency and bankruptcy and corporate law. His book, include A. Insolvency and the Bankruptcy Code of India, published by LexisNexis 2018, is a comprehensive section-wise commentary on insolvency and the Bankruptcy Code 2016, which was released by Justice S. Ravindra Bhatt, now a Supreme Court judge. Second book, IBC Case Digest, second edition, published by Bloomsbury, was released in February 2020. Third book, bestseller book, Analysis of Cases of Limited Insolvency Examination, third edition, co-published by Bloomsbury and Transition. Next book, Corporate Directors, Role, Responsibilities, Powers and Duties of Directors, published by LexisNexis 2016. Company Law Ready Reckoner, second edition 2018, published by Walter Kluwer. Mr. Ashish Makhija is an avid contributor of articles in the journals and online portals of repute, such as the Chartered Accountant, the Chartered Secretary, the Resolution Professional, Current Tax Reporter, the Market Mogul, to name a few. He has contributed to Indian Law Reporter, a law report published by High Court of Delhi from July 2013 to May 2016. He has regularly written blogs on professional topics of professional topics at ashishmakhija.net. He has a distinct followers for his writing skills. He has served as a member of monitoring group of ICSI in the Institute of Insolvency Professionals. He also serves as a member of the Board of Advisory, Amity International Journal of Juridical Sciences, Amity Law School, Noida, UP, India. He is on the advisory board of IP Foundation, a trust to facilitate and address issues in the field of insolvency. He has also served as a member of the committee formed under the directions of Delhi High Court for checking the status of technical glitches arising in filings done on MCA portal. Members of the drafting group of the high-level committee formed by the Ministry of Corporate Affairs for amending acts of three professional institutes, ICAI, ICSI, and ICOAI. A special invitee to the Corporate Law, Corporate Governance Committee of the Institute of Chartered Accountants of India 2017-18. He has been a member of the e-corporate business working group formed by the Ministry of Corporate Affairs, Government of India for introduction of e-forms under the Indian Companies Act 1956. He has been the member of the committee formed by the Ministry of Corporate Affairs, Government of India for drafting of rules of several chapters, mergers, revival, rehabilitation, winding up, NCLT and ANCLATE under Indian Companies Act 2013. He has significant corporate board experience and has served as independent directors in Shipping Corporation of India Limited, Caterpillar India Limited, and other public and private limited companies. Friends, with this fantastic profile, and I welcome Dr. Ashish Makhija ji to our institution, to our Association of Corporate Affairs and Executives. And sir, we all are looking forward to your deliberations. We all are eagerly awaiting. Everyone has joined all across India. It's only because of you, sir. Though the topic is also very interesting, it's all yours now, and looking forward to your deliberations.
Thank you, Mr. Modi, for such a generous introduction. I don't know whether I deserve it or not, but at the end of the day, I'm so happy and I'm so delighted to be amongst all of you. And I can see such a huge attendance. And you are the one who have taken up this topic at a very early stage, and I think that's the relevant time. I must thank Mr. Jitendra Lohia. He got in touch with me. I think we spoke with each other and he invited me. And I was so delighted to accept this. Of course, I can see a lot of my friends, Mr. Anup Sangai, Mr. Sumit Binani, who's the chairperson of the committee, and Mr. Vivek Agarwal, who's a convener. So I thank each one of you and Team Association of Corporate Advisors and Executives. I think this is a fantastic work you guys are doing. And I wish that you will keep on doing the same thing in future also. Thank you so much for inviting me. friends, let's start in the right earnest, because I think the idea is to share knowledge. The idea is to understand the nitty-gritties of the new subject which has which has come upon us. And as Mr. Binani Sumitji has mentioned very rightly, that this particular subject is based on trust. Actually, he is absolutely right, because I have also been experiencing, and many of you must be experiencing, because some of you are bankers from banking field also, and many promoters do come to me. They say that today, if I go for OTS, well, there is a trust deficit. None of the banks are actually approving the OTS in a larger sense. Well, they are doing it. I'm not denying that they are not doing it, but they are wary. And in fact, yesterday when there was a seminar where DGM of SBI, Mr. Pandey, was also there, and I posed him a very direct and blunt question. I said, look, insofar as OTS is concerned, the banks are absolutely wary, and he agreed. He said, yes, the banks are wary. In fact, our bank is also wary. And what we are worried about? We are worried about, he says, the investigating agencies, if we agree to that. And two, there is no price discovery mechanism. They say this is an option which has been brought upon, you see, in the IBC through an amendment code, where the price discovery can be easily done, and they will not be fearful of this. And of course, whenever this kind of proposal is approved, that will be approved by NCLT. There will be a stamp of adjudicating authority, so they will have nothing to worry about. So I think he's right in that sense. So let's try to understand. What I've done, friends, is I've got a short presentation, and we'll discuss elaborately after that. So let me share that with you. What my idea is to clarify the concepts first. Of course, we have got rules and regulations. Everyone can read rules or regulations and read the time limits. I've also gone through it. I'll also cover a few of them, not absolutely not all. I can't cover all of them. But at the end of the day, first, our concept should be clear. That's the most important aspect which I would like to clarify. So friends, we are talking about here a new concept which has come on upon us. It is pre-pack insolvency resolution process. So I think the word which has been coined for us is PPIRP. We're not calling it PIRP, because PIRP generally is confused with personal insolvency resolution process. So let us call it as PPIRP, which is pre-packaged insolvency resolution process. So this is a new word which we have to see. Let me give you a short background on this. This is the work of a subcommittee of the Insolvency Law Committee, which was formed sometimes in June 2020, and under the chairmanship of Dr. Sahu, who is the chairperson of IBBI. They submitted their report on 31st October 2020. Comments were invited from the public in January 2021, and I think few of the roundtable conferences were also held, and I was also a part of those conferences at that stage. And the last date for submission of the comments was 21st January 2021. So after that, of course, they have been working within their own framework to really look at this, to look at the proper format of this particular aspect. Well, friends, what is pre-packaged insolvency resolution process? Let us understand this way. Number one, it is an out-of-court solution which is there. It's like a kind of a settlement, with the lenders. Speedier resolution, because the time limits are also shorter in this case. But they say that we would like to have, number one, the checks and balances. Checks and balances, when I show you the further slides, you will really understand and appreciate that what exactly is meant by checks and balances. And because there are a lot of declarations which are to be given by the corporate debtor, and even the avoidance transactions are also dealt in within this particular framework also. Well, it is an option of resolving insolvency. This is one of the important aspects which is to be looked into. Before we deal with it, let's look at some statistics. Total CIRPs as of today, they have been admitted are to the tune of 4,139. And this is as per the IBBI's latest report, which they have published as on 31st December 2020. And out of which CIRPs which have been closed under Section 12A, that means out of settlement, are 378, that is up to 31st December. CIRP which have been resolved are 317, and CIRPs which have led to liquidation are 1,126. Look at the statistics, friends. This is a huge percentage where the companies are going into liquidation at a speedier rate rather than the resolution. In fact, we wanted, or in fact, IBBI or central government wanted this figure to be reversed. CIRP resolution should have been in the range of thousands and liquidation should have been in the range of 300s or 200s. But unfortunately, it is now reverse. And look at the average time. 317 CIRPs which have been resolved till date, the average time is 386. If you believe it is average time, you can see what would have been the higher time. So probably the higher time is much higher than even 386. And 1,126 companies which are in liquidation, where have been ordered, average time of liquidation is 330 days. In fact, if you look at, because of COVID also, obviously this period has increased. But at the end of the day, this is not what was expected in IBC. Well, we wanted to resolve in 180 days. It is almost double of that. Everyone, all of us have to make effort, including the adjudicating authorities, because most of the delays are actually happening at the adjudicating authority level. Of course, we should not criticize adjudicating authorities because they are also doing their best. And I must give you an example. Yesterday, I was appearing before one of the NCLT daily benches. Can you believe 167 matters were listed? Can you think that 167 matters can be dealt by a court in a single day, where they are sitting only for 6 hours or 8 hours? How many minutes will they will devote to a single case? So they are quite, you see, overburdened. We appreciate that, but at the end of the day, we expect that the government to reinforce their, you see, adjudicating authorities benches. And I think in times to come, I understand that a process to appoint around 30 members is already on. It is in the final stages, and we will hear the names of the new you see bench members. These are the options which are available right now. Number one, court monitored like CIRP, we all know. Then there could be a scheme of arrangement, that means Section 230 schemes under Companies Act. These are all court monitored. Out of court is obviously you can negotiate, or you can follow the RBI prudential norms for stressed assets, which are there, where there is a press circular of RBI, and under which the OTS are happening. It's not that OTSs are not happening, but the system is pretty slow in that. Now, PPIRP is a hybrid formula. It is not purely out of court, and it is not purely under the supervision of the court. That everything is not required to be done under the supervision of the court. At the end of the day, beginning and the end, we will go to the courts and not anywhere in between. So this is kind of a thought of as a hybrid formula, where the stakeholders are empowered to resolve the stress of a corporate debtor as a going concern, and with the minimum help of adjudicating authorities. So stakeholders are empowered, like lenders, even the promoters also, they are also empowered. This was the design structure. The basic structure of the code should be retained. This was a major idea. And no compromise of rights of any party. Now, this line, my dear friends, you must underline it. No compromise of rights of any party, particularly in respect of operational creditors. So I think this will be a music to the ears of the operational creditors, that there cannot be any impairment to their amounts. And that's a wonderful news. Well, as far as the financial creditors are concerned, they can take a haircut, obviously, because this is a scheme of OTS. And as it happens in OTS also, when they enter into an OTS, obviously it is the financial creditors, they take a haircut or hit. It does not impact the operational creditors to that extent. So similar thing has been sought out here. And obviously, to prevent any abuse of the process, the framework should have adequate checks and balances, which already has now. It is already in place, and I will show you that. Now, one thing we need to really understand is how it differs from CIRP. It differs because, you see, basic structure of the code says creditor in control. Here in this PPIRP, friends, it is debtor in control. It is somewhere similar to SICA, where you see a rehabilitation scheme was pending under before BIFR, and in the meantime, the promoters were running the company as a going concern. Here also, it is the same thing. While the proposal is being considered, or a resolution plan is being considered, the promoters are in control and they can continue with the company. Of course, there will be a moratorium during resolution process, similar to what we have in CIRP, and then there will be a binding nature of the approved resolution. Now, this is something which is very crucial, friends. That is why I said it is hybrid. In OTS, what you do is you enter into an agreement with a bank. Well, we don't know whether anyone will follow it or not. But in case of an approved resolution plan, which has the stamp of adjudicating authority, which becomes a binding nature, just like Section 31, well, it is binding on everyone. So this actually makes the things much easier for the corporate debtors as well as for the lenders. So this was a framework that we should provide a framework for a pre-pack for resolution of insolvency under IBC. Right now, it has been made available to MSMEs only. Yesterday, in fact, I raised this point that this is a welcome step in the right direction. This is definitely something which was expected. But I also raised an issue that why to restrict it only to MSMEs? Why can't we go beyond, you see, medium enterprises? Can't we go to large enterprises? Well, the answer from IBBI is yes, this has been done on a trial basis. If we are successful on this, definitely this can be extended even to other companies also, the larger companies, which is a very good thing. And I think most of the companies will be very happy about that. Well, anyway, so we all know that this blends the features of formal and informal options. So this is what we are talking about, hybrid system. Let's come down to the brass tacks. This is an amendment ordinance, as Binani ji rightly mentioned that this ordinance was promulgated with effect from 4th April 2021. And 19 sections, new sections are being added, starting from section 11A and then 54A to 54P specifically for PPIRP. And then even section 67A and 77A are being added just to enhance some kind of punishments, penalties for false statements which are there. So there are 19 more sections which are being added. So now, after this amendment, friends, IBC will have 282 sections. So total number of sections today are 282, going up from 255 when the IBC came in 2016. And one of the unique features, I think everyone knows it, that all the IBC amendments so far, in fact, minimum one amendment has happened every year in IBC from 2006 onwards, and all amendments have been through ordinances only. So this is a unique distinction to IBC. Well, thereafter, the amendment acts will be introduced in the bills will be introduced and they will be passed. But every amendment has been done in IBC through ordinance only. Now, pre-packaged, these were regulations were also announced on 9th April. In fact, along with that, rules have also been announced, and there is a notification which has been issued under Section 4 also. So I'll deal with that in a little while. Now, the question which is asked is why MSMEs only at this stage? Number one, the ordinance recognizes that MSMEs are critical for India's economy. And it is also recognized that they contribute significantly to the GDP of the country. And as far as employment is concerned, well, sizable population is employed by them. And there is an absolutely urgent and a critical need. Rather, I would not say urgent, it is a critical need to address the needs of MSMEs for insolvency resolutions. Because if we can retain our MSMEs, my dear friends, I think our economy can grow at a much, much larger pace. And this is an attempt so that at least those problems can be solved out here. And obviously, to provide an efficient, alternate insolvency resolution process. So underline the words efficient and alternative. So this is an alternative which is thought to be you see, very efficient system. Okay, let's come down to more specific details, friends. Now, who is eligible? Number one, as we said, MSME is eligible, and only it is available to those MSMEs who have committed a default. Now, a big question was also there before the subcommittee, whether it should be prior to default also, or what we call it as imminent default. Supposing, as the promoters know that we are going down the drain, we are going underwater, maybe we are going to commit a default in say 2 months down the line. Should this be available to those people also? Well, they debated amongst themselves, and ultimately they said, look, the trigger point in IBC is default, so therefore let us restrict it to default. So here also MSME must have committed a default. I'm not saying NPA. NPA comes later. A default means even a single rupee default is a default. So therefore, there has to be a default which should be committed. But here, the minimum amount of default, that notification came yesterday. In fact, MC had already tweeted that earlier. but the minimum amount of default which has been announced yesterday through a notification is minimum 10 lakh of rupees. So it is available to MSMEs having committed a minimum value of default of 10 lakh rupees. So I can say if you have committed a default of say 5 crore, 10 crore, well, you are eligible. It is not, you see, let there be no confusion, because section 4, which has been amended, it says that central government can announce the minimum amount of default, and that minimum amount of default can be increased to 1 crore rupees. So friends, please understand, this is only a minimum amount of default. It is not maximum amount of default. So if any MSME committing a default of 10 lakhs or more is eligible for this particular PPIRP. Well, central government in a times to come, they can increase the minimum amount of default to 1 crore as they have done in other CRP cases. Well, right now it has been pegged at 10 lakh rupees. So this is what I wanted to clarify, that minimum amount of default has been pegged at 10 lakh rupees. Now, other things are very important. Section 54A, because it starts from there. Of course, there are some definitions which are new definitions are there, like base resolution plan. So base resolution plan is the plan which is submitted by the company to the, by the corporate debtor, provided by the corporate debtors, is simple definition which is there. And then what do you mean by pre-packaged CIRP process? What is meant by preliminary information? Those simple definitions are there. And there is one more date which is there, pre-packaged insolvency date, right? PPICD or PPID, whatever you may call it. So whenever the application for initiation is admitted, well, that will become the pre-package, insolvency commencement date. So those dates are all mentioned out there. Okay, so these are, you can say, consequential definitions which have been brought in. But let us come down to very interesting aspect. Number one, the first requirement under section 54A, which is the most effective section, is because chapter 3A has been added now. So after chapter 3, now we have chapter 3A, and chapter 3A has been nomenclatured as pre-packaged insolvency resolution process, PPIRP. Section 54A says that the entity, the corporate debtor, A, if having committed a default, and then an application for initiating PPIRP can be filed if the corporate debtor is classified as MSME. So let us understand this. This is extremely important, friends. Whatever the words used are, it says that an application for initiating PPIRP may be made in respect of a corporate debtor classified as MSME. And classified as under which section? Under, of course, section 7.1 of MSME Development Act of 2006. So this is what it is required. I was actually I tried to look at in more details. Now the question which can arise is, A, because of my definition which was introduced in on with effect from, I believe, from 1st July 2020, the definition of MSME was changed, right? Investment in plant and machinery, 1 crore for you can say the small industries, it was 10 crores. For medium industries, it was 50 crores, and annual turnover limit was 5 crores, 50 crore, and 250 crore for micro, small, and medium. I think everyone is aware about that. Now, I was wondering that supposing I have, investment in plant and machinery not more than, say, 50 crores, and I have an annual turnover of less than 250 crores. Now, I am classified as, a medium enterprises. Do I need a registration? Is the registration mandatory for starting the process of PPIRP? Well, because the law uses the word only, it says classified as so and so. Now, classification and registration are two different aspects. Because registration is required in section 8. The reference to section 8 is missing in section 54A subsection 1. So I was slightly looking at finer details. Yesterday, because when the regulations and rules were not there, I posed this question, and the IBBI is the whole-time director who was there. He, in fact, had the copy of the rules and regulation, and he checked up and he said, no, yes, Udyam registration is required. That is what he mentioned. But now, since the rules have come, let me share with you those rules for a moment, because then the things will become clearer. I'll just stop share this, and I'll just share on the screen the rules which are there. Okay, these are the rules which have come, friends. I've looked at the rules. In the rules, nothing is mentioned about Udyam registration being mandatory. But when I looked at the form, this is the form which is to be filed. It is form number one. Form number one is to be filed. It is a form of application when you want to initiate the PPIRP. Well, here, what I found was this column number 8. I'm just showing you on the screen. It says details of the corporate debtor for the purpose of section 54A1 of the code. It says Udyam registration number as per notification number so and so of Ministry of my MSME. Attach a copy of the latest and updated Udyam registration certificate. Now, to that extent, it is fine, but there underneath they write or. They are writing or. So either if you have an Udyam registration, please attach a copy of the Udyam registration certificate. Well, that is and you are done with. If not, even then, the company is eligible, the corporate debtor is eligible, provided you are able to show or demonstrate that your investment in plant and machinery or equipment and turnover, which is calculated as per this notification dated 26/6/2020, well, it should be within that limit and you have to attach a proof of that. So even if you are not registered, so now the conclusion is registration is not mandatory insofar as for filing of the application under PPIRP is concerned. If you have registration, well and good, attach the copy of Udyam. You don't have to prove anything else. But if you are not registered, even then you are qualified, but then you will have to demonstrate probably with a evidence, with a chartered accountant certificate or a company secretary certificate or whatever professional certificate, along with the documentary proof of investment in plant and machinery or equipment or turnover. So these are the things which are now clarified, you see, in the form itself. Because I was also wondering when yesterday IBBI representative mentioned that Udyam registration is mentioned in rules or regulation. I was looking from a legal angle. Well, if the law is silent, how can you bring up an extra requirement through the rules or regulations? So maybe if somebody could have challenged it, it could have gone. So I think IBBI has done, or rather Ministry of Corporate Affairs has done good, where they say this is an alternative. So it is either this or this. So I hope I'm able to clarify this position, that registration as MSME is not mandatory, even if you are not registered, but you will have to demonstrate and give proof that you are falling under either micros definition or small or medium enterprises definition. Okay, so let us come back to our slides now. So having clarified this part, then the second condition is not undergone CIRP or PPIRP during 3 years preceding the initiation date. So what they are trying to say is this, and this was there in the report also and in the background paper which was issued by IBBI. Well, what they are wanting is that if you have already undergone CIRP or if you have already undergone PPIRP at any stage, so 3 years must be the cooling off period before you can bring out another application. Otherwise, what will happen? Today you go and this is like an OTS only. So today you go and get your plan approved, and after 6 months you come back again and say, no, I want another plan because even I can't pay this. Well, this cannot be permitted. Repeated applications should not be permitted. So therefore, the government has thought 3 years is the cooling off period. Well, there is a small controversy here, a small contradiction which I can see in the sense that if we go to section 11, which talks about CIRP, who is not eligible? There, the cooling off period is 12 months, isn't it? We all know that there is a period of 12 months which is mentioned there. And in fact, now they are actually trying to bring in another section in section 11. They are trying to bring in clause number BA. So after clause B, this ordinance amends that section and brings clause number BA, and it says who is not eligible. It says corporate debtor in respect of a resolution plan has been approved under chapter 3A, that is PPIRP, 12 months preceding the date of making the application. Now, I was also looking at it that are they serious? Because at one place they say 12 months is the cooling off period. But here, as far as the eligibility is concerned, under 54A, they are saying 3 years period, which is there. So anyhow, I think we'll have to harmonize both these sections. 11BA, and then section 54A, 54A2, and this is clause number A, which is there. So I think this needs to be harmonized. But let us presume 3 years is the cooling off period, because Harmony will say 3 years should be prevailing there. Because that was there, that is the intention, that was there in the report, that was there in the background paper. So therefore, that intention should prevail over that 1 year or 12 months period. So there is going to be a little controversy on that for some time, but I don't think this is a major one. I think people can resolve, I mean, the courts can resolve that. Then it also says not undergoing CIRP, which is quite logical. If you're already under CIRP, you can't come under PPIRP. So this is one bar. If your CIRP is already started, my dear friends, then you cannot come under this. Okay, before going further, let me also, take up very interesting things. Well, there could be a possibility that an application for CIRP is pending already before the adjudicating authority, right? So that could also be the situation which will be there. So section 11A, well, deals with these kind of situations, that what is going to be dealt with in these such cases which are there. Okay. Well, supposing the application is already pending. Section 11A, which is a newly added section, it says that if an application is filed under PPIRP, that means that is under section 54C. 54C is the enabling section where you have to file. They have given a 14 days period. So if your CIRP is pending, supposing CIRP is filed, say today, right, 9th April or 10th April. Today is 10th. Yeah, today is 10th. So within 14 days, if PPIRP is filed, that means by say 24th April, then adjudicating authority will first dispose of this application under PPIRP. But if PPIRP is filed later than 14 days of the application, which is pending under either 7, 9 or 10, then adjudicating authority will dispose of that application first. So this is a 14-day window period that has been given, which is there. That is why these regulations have come very quickly, and the representative of IBBI yesterday admitted very openly, and I really appreciate this openness and honesty, that their rules or regulations may not be in sync with the law. There may be certain problems could be there because they have done it in a hurry, because they have to modify it in a hurry. So therefore, there could be some problems, but he admitted that he said we'll iron them out over a period of time. So not undergoing CIRP is one of the conditions. Not under liquidation is also one of the conditions. So I think two things are clear. If the company is already under liquidation, you cannot start PPIRP at this stage. You are already under CIRP, you cannot start PPIRP. So these are the two important conditions which are there. Next one, I was little also you can say surprised to see this condition. Well, of course it is right, but let me tell you what is my anxiety towards this. It says corporate debtor should be eligible to submit a resolution plan under section 29A. Now, I am slightly confused on this. Now I am slightly confused. Because here the corporate debtor is itself coming on its own and filing a PPIRP, and they will remain in charge with the promoters, and they will be submitting the plan. Now, the law says that the corporate debtor should be eligible to submit a resolution plan under section 29. Now, supposing I have already committed a default, obviously I am eligible. But if it is declared as an NPA, I am debarred under 29AC, but because of section 240A, I am eligible because that does not apply to MSME. So because this is only for MSMEs. So 29AC gone, but other conditions have to be satisfied by the corporate debtor. So please remember that, except those subsections which have been exempted under section 240A, all other conditions under section 29A have to be satisfied by the corporate debtor. And one more thing which I would like to clarify, the plan under PPIRP can be filed either by the corporate debtor individually or along with any other person also. So supposing you don't have any money, you find an investor, he joins hands with you, and both of you together file the plan. That is also permitted. This is not only the corporate debtor, but that person who is joining hands with you, obviously he or she must also satisfy the requirement of section 29A. So I hope I'm clear on this. Now here you see the process starts. The process is the financial creditors now get huge importance. And when I'm saying financial creditors, I'm talking about unrelated financial creditors. Unrelated financial creditors, first of all, they will propose the name of the insolvency professional for conducting the PPIRP with 66% majority. And financial, in the value of the financial debt, whatever the value of the debt is there, 66% of that must propose the name of an IP. So I think I must clarify all doubts. Who is going to appoint an IP? IPs are going to be appointed by unrelated financial creditors alone. So it is basically kind of a COC or kind of banks only. So my suggestion, $1 million suggestion is start liaising with the banks, because at the end of the day, they are now going to propose, get your name on the panel of the banks, only then you have any chance of getting this kind of a business for you. So start doing that. It is not the corporate debtor who is going to appoint. It is not anybody else. It is the bankers or maybe unrelated financial creditors. So ARC companies or the banks, now you'll have to have good liaison with all of them. Okay. So this is what is the proposal. I mean, they will propose the name. Then majority of the directors and partners have to furnish declaration. So friends, here what we are talking about, these conditions is prior to submission of the plan. Right now there is no plan, but these conditions must be satisfied first. Then majority of the directors of the company or partners of the LLP must furnish a declaration. Now that is extremely important, that they need to submit a declaration. Well, that declaration, my dear friends, is a serious declaration which is there. Okay. So those declarations are to be there. Number one, what they are saying. The declaration says that CD will file this application for PPIRP within a definite time, but not exceeding 90 days. So window of maximum number of days is 90, but then CD has to commit that they will file within, say, 60 days, 30 days, or whatever time they want, but they can't exceed more than 90 days. So within 90 days, whenever they moot this proposal, they must file that application. So process has not yet started, friends. It is only in the kind of a pre-approval stage. Then PPIRP, they have to give a declaration that this PPIRP is not being brought to defraud any person. This is the declaration which they have to give. And then they will also give the name of the IP which was proposed and approved by the unrelated FCs by not less than 66% of the voting power. And that is in accordance with the value of the debt, not in the numbers. So if these three declarations are to be filed or given, then not stopping here, they need a special resolution, or 3/4 of the partners of the LLP must resolve to file for the filing of PPIRP application. So now, not only this process, but even their special resolution is required. So it is not an ordinary resolution. The shareholders must approve this. And then CD will obtain 66% approval of the unrelated FCs for the filing of the application. So there are two things. First, they are approving the name of the IP. Then all these declarations and everything will go. Special resolution obtained. Then they will apply to the unrelated financial creditors, and they will obtain their 66% approval for filing. So even for filing, they require their approval. Okay. And then CD will also prepare, the corporate debtor will prepare BRP. This is known as base resolution plan. Now, because this will become a base for the competing resolution plans to that. Okay. But they have to conform to the requirements which are mentioned. Obviously, the requirements are to be there. So this is exactly what needs to be done. So three things which are required to be done by the CD. Number one, they have to, prepare the declarations. They must provide declarations to the financial creditors. They must provide special resolution to the financial creditors. And third, they must provide base resolution plan to the financial creditors. And then they must seek approval of the financial creditors for filing of the application. As far as that is required, has been pegged at 66%. In fact, in the earlier proposal, it was a simple majority, but now it has been changed to 66% to make it in sync with the entire code. Now, till now, the process has not been initiated. Now, RP has already been appointed now because the name was proposed. Now he comes into picture. Now, what are his duties? His duties are clearly mentioned in next section, which is section 54B. Number one, he is going to prepare a report. Now, what is that report going to contain? A, confirm the eligibility of the CD under 54A, that they are eligible. I showed you those eligibility conditions, so he has to certify that. Two, he will also certify that base resolution plan conforms to section 54K, because section 54K talks about the plans. And then he will have to file reports and documents to IBBI, and those reports and documents are, friends, they are huge. There are a lot of forms which have come into regulations. I believe there are more than 16 forms which have been notified. Well, those forms, reports and documents, and everything has been documented. In fact, report is also, there is a form for that purpose, and other documents which are required to be attached. So those documents are already mentioned in regulations now. And then duties of the RP under section 54B, this section will they cease on failure to file application for PPIRP within the definite time period, or if the application which is filed is admitted or rejected. So RP will continue to function. If the till the time the application, that means the time period of whatever definite time period which has been committed by CD, not exceeding 90 days, or if the application is filed and that is rejected or admitted, then this RP ceases to act as an RP for this particular purpose. So for the prior to filing, the role of RP starts from that date. And the fees, which is as may be specified, fees will be paid to the basically to the RP, and this will form part of the PPIRP insolvency cost if it is admitted. So obviously it has to be part of the insolvency cost. Now, coming to the filing of the application, 54C is very clear on filing of the application. Who is going to file? Let's be very clear. It can't be filed by OC. It can't be filed by any FC. It has to be filed only by the corporate debtor. In fact, the word used is corporate applicant. Obviously, on behalf of the corporate debtor, a corporate applicant will file. Now, what they have to attach, these are the simple things. And in fact, if you look at form number 1, which I just showed you, that also contains a checklist which says declaration, whatever declarations have been given, that it is not for the purposes of fraud and all everything. And then special resolution is to be attached, approval of the financial creditors which they have given for filing, consent of the RP to act as RP, any report of RP which has been given under section 54B. And then this is a more very important thing, and rather I would say sometimes it may become a non-starter. I don't know, but I believe that this may be a non-starter. Here, the corporate debtor has to give a declaration that whether there exists or there does not exist any PUF transaction, avoidance transaction, or fraudulent or wrongful trading. Now tell me, my dear friends, will any corporate debtor write that there exists PUF transaction or fraudulent or wrongful trading? Now, if they write, well, they are asking themselves to be investigated, isn't it? They are themselves in trouble. When you start admitting that, oh, there is a fraudulent trading or a wrongful trading or there is an avoidance transaction, isn't it? So I don't know what kind of declaration they require. Generally speaking, everyone will say that it does not exist. But if they write in the declaration that it does not exist and the RP finds out later on that there exists, then they are in trouble. Then they are going to be prosecuted. And there is a new section which has come, section 77A. So therefore, this is a dangerous section. This section has to be taken care of in a very, to be handled very carefully. So it is a double-edged sword. If you say no, later on it is found, you are in trouble. if you say yes, even then you are in trouble because the matter will straight away go for investigation. So the corporate debtors have to be extremely careful while writing this thing. So they have to be, I mean, probably this is meant for, the genuine and the honest kind of promoters who are there. So maybe it is meant for them. Okay. But I was only wondering that, look, and there is a serious issue out here in one of the sections. I'll deal with that in a little while. The fact of the matter is that if there is an avoidance transaction which appears, then I told you that it is a debtor in control, but then the vesting of the management can be transferred from the debtor to the RP, provided there is an incident of any avoidance transaction and in the opinion of the adjudicating authority. So they can say that, look, we are vesting the management to RP now. It has got serious consequences later on. I'll deal with that in a little while. And they also have to attach information about the books of accounts and the creditors default and everything. I think those application procedural part is simple, so I'm not dealing with that. Now, this comes to the application now. This is crucial. 54C. It says that adjudicating authority will pass an order within 14 days. Within 14 days, that order is to be passed. That means either you admit or reject. And then what will be the date of ICD here? PPICD. So I'm calling as PPICD. That is date of admission by the adjudicating authority. I think that is simple for us to. So, but here the time limit which has been given to them is 14 days, which has to be done. Okay. Well, 14 days, if somebody asks me whether it is mandatory or directory, well, it is going to be directory. It can't be mandatory. Okay, let's come out to be the other time limits which are given in 54D as similar to section 12. This process of PPICD, my dear friends, will go on for 120 days. It is not going to go for 180 days as again as in CIRP. So it is for 120 days. The entire process, including the approval of adjudicating authority, is expected to be done within 120 days. Very ambitious. Very, very ambitious. Well, I would say it is possible because here the management is cooperating and the management is also wanting this some solution. So probably I will believe it is easier and possible. But unfortunately, there is no provision for extension as we have under section 12, but there is no provision for extension which has been there. But yes, always we can take an advantage of exclusions, isn't it? Okay. Then RP has to submit the approved resolution plan within 90 days. So now 120 days is divided into two parts. 90 days has been given to the RP and the COC and the corporate debtor to set your house in order, approve whatever resolution plan is there, and then 30 days window has been given to the adjudicating authority for approval. So 120 days is the maximum period. 90 days plan must be approved. If within 90 days plan is not approved, then RP will file an application for termination of PPIRP. So 90 days, my dear friends, is sacrosanct. Nothing can go beyond 90 days. Everyone will have to work in a very, very fast track mode. 90 days is the overall limit is given and 30 days has been allowed to the adjudicating authority. So the overall time period is 120 days. Well, what happens to the moratorium and the public announcement? Yes, that there is a section similar to what we have in CIRP. We have got section 13, 14, 15. Here we have got 54E. Number one, they will adjudicating authority will declare moratorium along with the admission order, and they say section 14 subsection 1 and 14 subsection 3 will apply mutatis mutandis, which means which will apply equally to these. So 14.1 and 14.3. They have not made applicable 14.2 and 14.2a. Please mark this. It is only 14.1 and 14.3, right? 14.2 and 14.2a will come little later. I'll show you that. Then they will appoint RP, which is named in the application because his name is there. Supposing there is no name or some disciplinary proceedings are pending, then obviously NCLT can appoint, adjudicating can appoint anyone else. Then they will also cause public announcement for initiation of PPIRP. and moratorium continues till PPIRP ends. So maximum by 120 days you can call it. Okay. Now, what do you mean by public announcement? And public announcement, I was looking at the regulations, it is to be done within 2 days, because the word which is used in law is immediately, and in regulations it has been defined as 2 days. So it is not 3 days, my dear friends, as in the case of CIRP, it is 2 days from the date of initiation, from the date of this. So it's a very quick job actually, isn't it? Okay. In 54F, they have given the powers and duties very clearly. They have mentioned what are the duties and what are the powers of the RP. Well, in this case, when I was talking about public announcement, public announcement is only an announcement that the company is under PPIRP. Public announcement is not for the purposes of inviting claims, because there is no provision of inviting claims there through public announcement. No one is supposed to file claims because this is a very shorter process. How that is to be done, let's go and understand one by one. The duties of the RP includes confirm list of claims submitted by CD. Now, this is exactly what the point is. As soon as the RP is appointed by the adjudicating authority, within I think it is mentioned within 3 days. Within 3 days, the list of the claims, as per the books of account, have to be handed over by CD to RP, and RP will then confirm that list. So it is based on the list provided as per the books of account of the corporate debtor. We are not inviting any claims. Based on this list, he will inform the creditors about claims separately by either by email or by sending postal mail or whatever it is. So he will inform the creditors about their claims, and if the creditors have any objections, they will file objections. He will consider their objections and he will update their claims. This is the process which is going to work under PPIRP. There is no public announcement for invitation of claims. And then he is not managing the affairs of the company, but he is monitoring the management of the affairs of the CD. Because who is managing the company? Same existing promoters. Who is going to monitor? RP is going to monitor. So if there is a breach, then he will inform the committee of creditors if there is any breach of obligations by the directors. And he's also supposed to attend all the board meetings. That is also mentioned that he will be attending all board meetings in the meanwhile. Then constitute committee of creditors. Then he will constitute COC, and COC is to be constituted in accordance with Section 21 itself. All financial creditors, unrelated financial creditors. So related financial creditors are not part of COC. And in case financial creditors are not there, then again the same process. Operational creditors, top, I think here it is top 10. I'll have to recheck on that. Top 10 operational creditors are there. One representative of workmen and one representative of employee. So they will be part of the COC in case there are no financial creditors or there are no unrelated financial creditors. And then he will attend all the meetings. He will also prepare information memorandum. Now you must be wondering why information memorandum is required when the plan is going to be submitted only by the CD. Well, friends, here is the catch. The base resolution plan is prepared by CD. Now it goes to the COC. They may or may not approve it, and they may ask the RP to prepare an IM, and also invite prospective resolution applicants for the competing plans. So I'll explain that system in a little while, but I wanted to clarify that doubt right here. That is the purpose of IM here. And the preliminary IM will be prepared by the CD. So his job is lesser. So basic work will be done by the corporate debtor. He's given a draft document and he will finalize that document. So your job is little lesser than what was there in CIRP. So little effort is taken care of by the corporate debtor itself, because we expect them to help us. And then also file application for PUF transactions and also for fraudulent or wrongful trading. Here comes that application. So even under PPIRP, applications under avoidance transactions or fraudulent or wrongful trading, they are also required to be filed. And the time limits are pretty tight, my dear friends. I must tell you, The time limits are very, very tight under these provisions. They are not as liberal as in case of CIRP. In fact, I won't say they are liberal in CIRP also. In CIRP, do you remember what are the time limits? 75, 115, and 135. Opinion, determination, application. Isn't it? Here also, same process, but the time limit, instead of 75 days, it is 30 days. Instead of 115 days, it is 45 days. Instead of 135 days you get for filing the application, you get 60 days. So 30, 45, 60. Okay, I hope I'm clear on this. So this actually exercise has to be done even in these circumstances. So here comes that point which I was mentioning earlier. Now there is a declaration given that there are no PUF transactions, there are no fraudulent trading, there is no wrongful trading. Here, if these are discovered later on, then it comes into a serious consequences. So the promoters have to be absolutely sure about it. One suggestion was given yesterday by the DGM of SBI when I was there in a seminar. He said, and in fact, I pointed out, you see an amendment in section 65 also. I said, look, if you are also a party and there is something wrong in the company, then probably the bankers will also be taken to task. And he agreed with me, my viewpoint, and then he suggested one thing, which of course is missing here. They say, as a matter of abundant caution, the banks should ask the CD, which is going to have an informal talk first. Obviously, they will have an informal talk first. They say at that time, probably the banks will insist on the forensic audit itself. Now, if that forensic audit is carried out, nothing is found, then even the promoters can also say, give a declaration that yes, there are no such transactions. I think that's a good idea. I mean, even if it is not mentioned in the law, if this process is followed, this standard operating procedure is followed, I think this will do a lot of good things for the promoters because it will protect them also. It will ring fence them for this giving this declaration. Okay, so let us look at the powers. Despite the fact that he is not managing the company, he has access to all books and records and info of CD because he has to update that claim list. He has to verify that claim list. He can access all electronic records from information utility. He has not only that, he has also an access to books, records, and documents which are available with government authorities like tax authorities or GST or statutory auditor or accountants or even any other person. So whosoever has custody, he can call for that information. He must attend the meetings of the board and all committees, and he can also appoint accountants, legal or other professionals to assist him or maybe for the appearance in adjudicating authority. So these are his powers, which are very well defined in section 54F of the code. Okay. And then he has to collect information of assets, finances, and operations for finding out avoidance transactions. And the look back period here, it is 2 years prior to PPICD. 2 years prior to PPICD, it is standard. Okay. Banks have to furnish information to RP as and when it is required by him, and all personnel to cooperate with him. So this is all similar to what we have in CIRP. Like section 19, even he has been given a power that if any personnel do not cooperate, well, you can use the section 19.2 and 19.3 that has been made applicable to this process also. So I think the same process, yeah, entitled to file application under 19.2. And then fee of the RP, which is, you see, a very moot point, which everyone wants to discuss, that how the fees is to be decided. Well, the fees, they say, that will be decided, of course. In fact, here they are simply mentioning that fees will be a part of that PPIRP cost, which is there, insolvency process cost, which is to be done. Okay. Obviously, the fees is to be decided by the committee of creditors only. Now, this is what the clarification is there. COC may impose limits to the fees and expenses. Fees and expenses prior to PPICD, because the person is working, isn't it? He is already working. ICD starts a little later because he has already prepared his report. He has done so many things. He will also get a fees and expenses, but it is subject to ratification by COC. Well, friends, here what I suggest is that because there is a lot of problems which are coming on fee part, and I'm also dealing with many cases where the fees of the RPs have not been approved, or IRPs particularly. They are not ratified. They are running from pillar to post to get their fees. So what my suggestion is, if we are not careful, nobody is going to help us. So let's be careful. Now, if we must write down in our engagement letter that, look, my fees is going to be this much. If the fees is not approved or ratified by COC, then you are going to pay me. Be strict on this. Don't jump just to get the work. If we are strong enough, supposing I refuse work because the party is not giving me such kind of an engagement letter, be that it is me, then I will believe that my other friends, say, like Mr. Anup Kumar Sanghi or Mr. Ayyadurai or Mr. Vishwanath Chaudhary, well, they are also going to refuse. If we can have that kind of unity, I think we will be surviving in a better environment. So let's have a standardized. What I'll do is, what I can suggest is, I think this association is doing a fantastic job. What I can suggest is, why don't you create a standard engagement letter for these purposes, whether for IRPs, whether for RPs, or whether for PPIRP. Let's create a template of an engagement letter. Let us circulate it to all our fraternity and ask them to get it signed, so that their fees is protected, my dear friends. Why do you want to run to adjudicating authorities who are not taking any decisions? And even if they are taking a decision, they are taking in a very abrupt manner. Number two, you are sent to sometimes IBBI. IBBI says we don't have any power. You have to go to other courts. I'll tell you one case which is very interesting. Fees of IRP not approved. He goes to NCLT. NCLT says pay X amount. The committee of creditors says we have not approved it. They challenge it before NCLAT. NCLAT says, yes, NCLT never had the power. Why have they done this? They say if any party is aggrieved, go to IBBI. So the IRP goes to IBBI. IBBI says pay Y amount, which is higher than X amount now. So they say pay Y amount. And IBBI writes in its order admitting that they don't have power. But since NCLAT has referred to us, we are deciding this. Now that order of IBBI is challenged by the COC in High Court. And High Court says, I don't want to get into the fee part. Go to NCLT and file a review application there. Now tell me, we came back where we started. So first it started from NCLT, went to NCLT, went to IBBI, went to High Court, and again High Court sends the ball back to the court of NCLT. When I was arguing the matter, the judge said that, Mr. Makhija, I don't want to get into this. Why can't you have a meeting with the COC and IRP and please try to resolve it? And believe you me, I made my best of my attempts and had 2 meetings, but unfortunately there was no consensus. We came back to the court. I said, sorry, sir, it cannot happen. But when I look at this, I actually am not very happy at this situation. So for my fraternity, I think you must be extremely careful. Get a proper engagement letter signed. Okay, this is extremely important. So it is subject to ratification. Then list of claims and preliminary IM. Now this is what I was talking about, that CD has to submit the within 2 days of PPICD, not 3 days. I think I mentioned 3 days earlier. It is within 2 days they have to give the list of the claims and with security interest to the RP for his verification and confirmation. And they will also submit the preliminary information memorandum. So you get some kind of a draft. Obviously, it will not take much of the effort to submit that. Okay. And now here comes the wrong information, that if any wrong information is given in the claims or in the preliminary IM, well, the corporate debtors are liable to pay compensation for any loss sustained to any person, and they are also liable for punishment under Section 77A, which is a new section which has been added, right? And the case for compensation has to be filed in civil court. They say NCLT will not entertain the case. Let you go to civil court. Anyhow, whosoever suffers a loss, let him go there. So this is the provision where the documents now come to the RP. Now, management of the CD, well, there are very simple sections. Management vests in the board of directors or partners. They will continue to protect and preserve the value of the property and manage it as a going concern, as in the case of CIRP, IRP does it, or RP does it. And they will continue to discharge their contractual and statutory obligations, like deposit of GST and everything. So this is quite simple. I can skip this. As far as committee of creditors are concerned, yes, here comes another responsibility of RP. RP to constitute COC within 7 days of PPI-CD. So he gets 7 days time. And update COC from time to time as far as the claims are being updated. Well, he will update the COC also. But any decision taken by the earlier COC, later on the COC is updated, that will remain valid. So I think that's obvious. First meeting of the COC within 7 days of constitution, because it is very, very time bound. So you get only, because you are getting the list of claims. You have to just entertain objections and update it, constitute whatever documents are with you on the basis of that, constitute COC within 7 days, hold that meeting within next 7 days. And provisions of section 21 will equally apply. That is as far as the committee of creditors is concerned, except 21(1). Okay, so that is what is the exception here. How they yeah, this is interesting. Vesting of management with RP. Well, friends, my first statement: management does not vest with RP. It remains with the corporate debtor and promoters. But there is a chance that it can come in the hands of RP. Under what circumstances? This is a circumstance. If the COC decides with 66% voting share that the management should vest with RP, they can pass a resolution. But the matter does not end here. I mean, they don't have the, you can say, full power. Now an application will go to adjudicating authority for a decision on this matter, and they will pass the order if it is of the opinion, either this or that. Affairs of the CD are conducted in a fraudulent manner, or there is a gross mismanagement of the affairs of the CD. So this needs to be proved. It's not that COC takes a call and the management vests in the RP. No, that is not going to happen. They will have to demonstrate either of this. Affairs of the CD conducted in fraudulent manner or gross mismanagement of the affairs. So friends, 54, you see this section, which is a very, very important section, 54J. Well, you can remember this section, J for jeopardy. This is jeopardizing the CD. And please remember this, because this has got severe consequences in further sections to come, and I'll show you. And this can cause the order of the adjudicating authority to bring that company into liquidation also. This has got serious consequences. So remember J with jeopardy, okay? So 54J is a serious section for the corporate debtors. Okay, so this is a simpler section. Okay, so this is a continuation of that. Upon the vesting, supposing the management vests with the RP, well, now all the sections of CIRP will now operate, including 14.2 and 14.2a. I told you earlier 14.2 and 14.2a, like essential supplies, critical supplies, they were left out because it was the management was with the corporate debtor only. So now once the RP takes over, now he needs the support of all these sections. 14.2, 14.2a, 17, 18, 19 also fully, 20, 25, and all these sections will now apply as if they are applying in CIRP. I think we are well versed with all these sections, so I don't have to deal with these sections. Okay. So from the date of the order, and I mean the vesting will continue from the date when the adjudicating authority says so until the period of PPI RP comes to an end. But I don't know whether this is possible proving out all within 90 days. I mean, this is really, really very tough to prove it. Okay. This is the main section, friends. 54K is the heart and soul of PPI RP. If you have not read any other section, will not matter. Please read carefully 54K. I can advise you that. Let me try to make it simpler. It is very complicated, actually. In fact, I wanted that it should be a simpler process. Well, it is very complicated. Let me explain it so that everyone understands. First, let's go down to first principle. Number one, CD will submit base resolution plan to RP within 2 days. No quarrel, sir. Along with the list of claims, 2 days. This also goes BRP because it is almost ready. And there is a permission which is given that this BRP can be individually or jointly with others. This is what I was talking about. So they can find an investor, they can join hands, it can be consortium or whatever. RP will present them to COC. BRP. So he will present BRP to COC. He is like a postman now. He is not applying his mind. COC will now provide opportunity to the CD to revise BRP prior to its approval. Okay, just give me a second. I don't know where I've lost my cursor. Yeah. Okay. Prior to its approval or invitation of PRAs. Now, there are two options which are available to the COC. And COC consists of unrelated financial creditors. A, accept BRP. B, you say, no, 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 please revise it because we are not happy with this. Or they can also say that, look, if you don't revise or you don't do anything, then we will call for the PRAs, prospective resolution applicants. So the choice is with the COC. So therefore, the plan which should be sent to COC in good faith and in complete honesty. Don't try to bargain or negotiate. If you try to do that, then the CD is going to be in trouble. So therefore, that is my advice. COC may approve the BRP if it does not impair any claims of OC. So now let's presume that COC is happy with the plan, BRP itself, or revised BRP, and they want to approve it. But then it says they may approve it if it does not impair any claims of OCs. So this is the condition, that no impairment of any claims of OCs should be done. And impairment has been defined that no impairment will be there if the OCs are being paid 100%. So if you deduct even a single penny from OCs, it is called as impairment. So this is what I said. OCs are completely protected, my dear friends. They are very happy for this. Okay, let us go to the next one. RP will invite PRAs to submit resolution plans to compete with BRP. Supposing this, you see, the COC says that, okay, now COC has not approved the BRP, or the BRP, you see, impairs the claims of the OC. So two conditions. In that, resolution professional is now required to invite prospective resolution applicants who will submit their resolution plans, and they will now compete with BRP. These are the two conditions. COC does not approve BRP. So if they approve BRP and BRP is not impairing, OC's matter ends. But if COC does not approve BRP, or BRP is there which impairs the claim of OCs, then RP will invite PRAs. So this is the condition which is there. And our PRAs will have to fulfill the criteria which will be laid down by the COC. Well, COC will lay down how they are going to evaluate this. And RP will then provide them the copy of IM and evaluation criteria. Now here comes IM. Because earlier you were wondering why IM is required. IM is required because of this. Because now new fellows are coming. Obviously, they don't need to know information, get the information about the company. So they will be informed about this. What will happen? All resolution plans which are in conformity, they will be presented to COC. COC will evaluate the plan, and then they will select a plan. Now, there are now two sets of plans. One, BRP. Second, what is the plan selected out of the plan submitted by PRAs. So now there are two plans. Let us understand that. Now these two plans will be compared. If the plan which they have selected is significantly better, the word used is significantly better than BRP, then committee of creditors will select it for approval. Okay. Let me explain the process once again, how we have reached to this stage. First, CD will submit BRP. Committee of creditors can ask the CD to revise BRP. And if they are satisfied, they can approve it, matter ends. If they don't approve it, or there is an impairment of OCs in the plan, then they will ask IRP to go to PRAs, invite PRAs. PRAs will present the plans. Those plans will go to COC. COC will examine them from against the evaluation criteria, and they will select the best plan out of it. Now that best plan will be compared with BRP. If it is significantly better, then creditors will select it for approval. So right now they are not approved it, they have only selected it. So please understand, don't get confused. It is only selection of the plan. Approval is yet to happen, because that selection of plan is to be compared with the BRP. So now the word is significantly better. Now, what do you mean by significantly better? Well, I was wondering, let me go to the regulations and see it. I saw the regulations when they say the plan will be significantly better if as per the criteria decided by the COC, and they have given us certain formula also. It can be a weighted formula, like you decide three parameters: upfront payment, maximum payment, and time. Supposing you decide three periods, assuming three parameters, and COC says we give a weight of 2 to the first parameter, weight of 1.5 to the second parameter, weight of 3 to the third parameter. Then compare all those plans, multiply with them, and then you come out which one is better. So this is what they are saying, that you will have to compare this significantly better. There's a huge formula, mathematical formula, which they will have to devise. So this is slightly complicated, but to understand in the beginning, but then it will not be very, very difficult. And then you see, significantly better is also a percentage. Supposing base resolution plan and the best plan. So supposing best plan is 20% better than the base resolution plan, assuming, and COC has already decided that if it is more than 10%, then we will consider as significantly better. So even significantly better is also left to the wisdom of COC. This is my point. So COC decides not only the evaluation criteria, COC also decides the parameter of significantly better. They come out with that matrix. This is where actually the role of RPs will also come into picture. I think they will be doing assisting the COC also. Okay, now if not considered for approval, then it will compete with BRP. So now it will compete with BRP. Now, one plan submitted either by PRA, which is selected, or BRP now will be selected for approval. And then COC will approve it by 66% voting share. This is what is there. Supposing it is not significantly better, then obviously they will compete. So competition will start only at that stage, not earlier. So it is little complicated to understand at the first stage, but it is simpler in a way I'm trying to explain it to you. So if not approved, supposing even that is not approved, RP will make application for termination of PPIRP. And termination of PPIRP, my dear friends, please mark my words, it does not lead to CIRP, it does not lead to liquidation. It means the company comes back to its original state from where it started. So if somebody wants to start CIRP, let him go separately. But there are certain other options which are there, which we'll talk about it. Okay. If BRP provides for impair, now here comes the problem. If the BRP says there is an impairment of claims, obviously COC is not going to approve it. But COC says, the law says COC can approve it provided the promoters dilute their shareholding or voting or controlling rights in COC. Okay. One more complication, isn't it? So the COC may require promoters to dilute their shareholding or voting or controlling rights. But if they don't require, then they will have to record reasons why they did not ask for. And then RP will submit the approved plan to A. And if not approved, then RP will make application for termination of PPIRP. So this is what the section 54K is there. Okay. Then comes the approval of the resolution plan, just similar to section 31. Adjudicating authority gets 30 days. I told you 90 days to 120 days. And they must meet the required plan, must meet the requirement of section 32, which is there, which is a very critical section. And there must be provisions for effective implementation. And then all other sections like 31.1, 31.3, 31.4 will also apply to these plans. And AA will reject plan, terminate PPIRP, and order liquidation. Now here comes the seriousness. Liquidation will be ordered, can be ordered only by adjudicating authority and not by the COC. In CIRP, COC can take a decision to liquidate, but not in PPIRP. But here, AA can take a call on what stages. Number one, when they have passed orders of vesting of management. I told you this is a serious one. So when the order is passed under 54J, J is in jeopardy. So jeopardy is there, then they are in real trouble. or plan which was approved by COC contains impairment without change in the management or control of CD. Even then at that stage, then the order of liquid, that means they will reject the plan, terminate PPIRP and order liquidation. And then PPIRP cost will now be considered as liquidation cost because there is no CIRP, there is nothing. I hope I'm clear on this. So this is little serious business. Termination of PPIRP, well, 90 days. And plan not approved by COC, supposing they do not approve the plan, so PPIRP tenure comes to end, or COC decides to terminate with 66%. Well, this is the option. COC says terminate PPIRP before the expiry of the period. Well, they have got the option. Or PPI, when the PPIRP is terminated, obviously then it comes to the termination of that period. But avoidance applications can continue. If the avoidance applications which are filed within the 60th day, well, avoidance applications can continue. That is the law which is there. CD will bear the PPIRP cost if it is terminated. So your fees is short that CD is going to bear that cost. Now, if adjudicating authority has passed order for vesting of management to RP, then AA will order liquidation and PPIRP cost will be considered as liquidation cost. So even in termination also, when the order is passed, so why this section has come out again? Because that was approval. Here it is termination of PPIRP prior to approval. So similar sections are there or provisions are there in both. Okay. Then CIRP in PPIRP. Now coming to a very interesting question. COC has got now few options. B, reject the plan. C, terminate PPIRP. And D, they can also pass a resolution, let us start CIRP. But they have no power to bring the company to liquidation. This is what I'm trying to bring. They can decide for CIRP. So in that case, A will terminate PPIRP, will appoint RP as IRP. Well, this is, I was wondering, you have already acted as an RP, let him act as an RP. Why do you want to appoint him as an IRP again? So he becomes an IRP once again. And PIRP cost will be included as a CIRP cost. And this order will be deemed under 54O, will be deemed as an order passed under section 7. And insolvency commencement date, now it is not PPICD, it is ICD. And ICD is the date of order. That is under section 54O. And avoidance proceedings will continue. And reference to ICD will be equal to PPICD. It will not start from ICD now. It is actually PPICD only. Okay. So that is going to happen in that case. So friends, this was all about the overall picture. I hope I'm able to do justice because a lot of complications are there, a lot of parts are there. I've not dealt with few of the other things, like you see section 65, 67A and 77A, which are very simple sections. You can read that. Let me give you some opportunity to ask questions. So that is why I'm stopping it here. Maybe I'll request the organizers to help me to deal with questions. If there are any in the chat box or if somebody wants to be unmuted, I think I'm available. Yes.
Sir, Mr. Mahesh Podar has raised his hands.
Yes, sir.
So I'll be unmuting him.
Yeah, go ahead, sir.
Mr. Mahesh, you have been unmuted. Kindly go ahead with your question.
Yes. Good evening, Ashish sir.
Yeah, good evening.
It was actually a very nice session. I have two queries, sir.
Yes.
Generally, in the case of MSMEs, the banks are full of collateral security and personal guarantees.
Right.
So, how this will impair the process of the pre-package insolvency, as unless the bank is ready for the OTS, I don't think this will be come out as a very huge turnaround for the MSMEs because of the collateral and the personal guarantees.
Okay, see, as far as I'll answer it this way. See, as far as the restructuring of the debt is concerned, instead of OTS, this is the formula which has been thought about, where we believe that the bankers will be more comfortable and more confident because they are getting the stamp of the adjudicating authority. So that is one part of it. And because there is a price discovery also. The other part is now they are confident because say a plan has been given by CD, but supposing some PRA comes and he gives a plan which is better than, significantly better than him, well, they will say, raise this price, otherwise we are accepting it. So price discovery is there, so they are confident about it. As far as personal guarantees and other things are concerned, probably that will continue because at the end of the day, collaterals, they are not going to leave, because unless they recover their money, they are not going to leave the personal guarantees also. But if they are as a part of the plan, like supposing you are able to negotiate with them and say that, look, I want my personal guarantees to be released or reduced to that extent of the new debt. Well, if the bankers agree, then it will be a part of the plan, binding on everyone. And obviously, I believe that promoters are going to do that. Otherwise, what is the point of doing all these things, right? If they have to pay 100% out of their own pockets, there's no point of doing it. So this is my belief that this is going to take place. Okay. Anupji, you are muted actually.
May I ask a question, please? Yadurai
Yes,
here.
Mr. Ayadurai, please go ahead with your question.
Yeah. Good evening, sir. Pleased to see you back. Sir, my question is, the bankers have got their own internal benchmarks in terms of RBI guidelines for restructuring any of their debts under the extent OTS or SARFAESI or any other legislation. In fact, that recent COVID extension also under 2 years Common Committee recommendation, they have a typical benchmark, financial benchmark, like various ratios. Now, the approval of plan is already, it is their prerogative whenever a base plan or any other plan is coined out by CD or RP. Now, my question is, there are two questions I want to ask. Now, my question is, can the RP, because the selection of RP is entirely within the purview of COC, again, will you not go back to square one, the same old OTS schemes of SARFAESI, will it not prevail? Because ultimately the banks are also accountable to their own management in terms of their money value.
Okay, I don't see that, because yesterday Mr. Pandey was there from SBI. Now he says that, look, as far as OTS is concerned, they are bound by the extant regulations and those rules which are there, extant guidelines of RBI. But here they say they have got more freedom, because there is a process of price discovery. Like supposing a promoter comes to me and offers me, say, instead of 1800 crores, he says, okay, I'm going to offer you 850 crores. Then I'll say, okay, let me discover the price. Let PRAs come. And supposing somebody offers 900 crores, then they are happy about it. So then they don't have to deal with 850. Now they are getting 900 crores, and it gets a stamp. So they are safe. So what they are doing is they are doing as a collective mechanism and not sitting in their air-conditioned offices.
So in PPARP, the CD continues and try to rest with them the management.
Right.
Which is not exactly in line with the basic BLRC, which you taught me when I attended your class. Because the BLRC committee, the basic preamble is to shift the ownership from the defaulting debtor to the creditor. That was the very basic. Okay, MSME, you want to soft pedal, you still want to allow the CD to retain management. My only question is, if that is the case, you say 54J is a jeopardy. It is not a jeopardy. It is a jeopardy to the RP also, because he has decided some fees to begin with. Now, if he takes over the management, his fees can't be the same. Always fees is a hot contentious issue. And now, what are all the liability, especially from statutory compliance, an RP will be subject to if the management is vested with the CD, defaulting CD?
Okay, see, two questions. As far as the second question is concerned, since the company is being run by the CD, so obviously I would say that RP is safe to that extent, because all contractual and statutory obligation, in fact, it is mentioned in the code itself, they are the responsibility of the management. So I think it's a best scenario. It is a win-win scenario. Here you are like a, you can say, a friend, philosopher, and a guide. You are there just to monitor. You are not there to do any business there. So you are on a safe pedal. That is one part. Second is, as far as BLRC is concerned, well, friends, we have moved a long way. We have come a long way from BLRC. So it is BLRC plus 5 years now. So I think the scenario has changed. So we have moved away from BLRC, and things are changing because it's a dynamic thing. And this is also coming on a trial basis. If it is successful, it may be launched even for large scale industries.
Okay. Fees will be revised if the management is vested with RP, sir?
Sorry, fees will be?
Fees review will be there if the management is shifted to RP?
Yes, it should be done. In fact, at the time of engagement, you should say that that, look, if I'm not looking after this is a good question which you have raised. In fact, it did not come to my mind, but I can answer it this way. Yes, you should also, in your template of engagement letter, you should say, I will charge X fees if management is not vested. I'll charge Y fee if it is the management is vested. Good observation, Mr. Ayadure. Thank you.
Sir, next question is from Bharati Daga. Bharati ji, you have been unmuted. Kindly unmute yourself and carry on with your questions. Bharati ji, kindly unmute yourself. Okay.
Hello, sir. How are you?
Yeah, I'm good.
Very good evening.
Yeah, good
Very
evening.
good evening.
Yeah, yeah.
Sir, my question was that you specifically mentioned that the RP or the PPIRP will be appointed by FC only. But if there is no FC, there are a lot of, because it's MSME, not every MSME has the banking facilities. So in case there are only operational credit, there are no FC. In that case, will the OC allowed to appoint the IRP, PPIRP?
Okay. Well, to honestly speaking, I've also not examined this aspect. I think we'll have to look at the provisions once again. And once I have the answer, definitely I'll answer that. So today,
So
honestly, this is a good question. So I'm also noting it down. And if I can find out quickly, then I'll tell you. Otherwise, maybe we can speak offline and then I can clarify.
Okay. Yeah. Thank you very much, sir. Thank you so much.
Mr. Pratim Bayal, kindly, please go ahead with your question.
Sir, good afternoon, sir. Sir, I have two questions. One is the impairment of operational creditor. What does it mean? What is impairment? And how? What is there any quantification amount or what? How it will be dealt with?
Yes. It is already clear. It has been clarified that if the operational creditors are paid less than the 100%, it is equal to impairment.
Okay, so it should be absolutely 100%.
Absolutely 100%. That is why I was very happy to see this, because here the OCs are being protected.
Yes, otherwise it could have been a problem. And sir, one more thing.
Because the reason is, let's understand the logic. The logic is because the company is running. So if the company is running, the operational creditors are supplying the material, so they are entitled to what they have supplied. So there should not be any impairment to their money. That's what the logic is.
And one more question, taking the clue of questions of the earlier speaker, that suppose if there is no FC. Now, if there is no FC, is there a chance of settlement? Because this is a kind of settling a debt. Okay, so will there be any situation like that if there this entire pre-pack is assumed that there is some kind of lending? If there is no lending, can this is a practical question, it's not a direct legal question. Can there be situations where there is no FC, only OCs are there in particular pre-pack condition?
Well, I can anticipate one situation where, of course, only operational creditors are there, say, assuming you have to pay 10 crores to them. Well, you can settle with them that, look, there is no impairment, we're going to pay 10 crores, but not today, but maybe in next 3 years. So by that time, you will not go to for CIRP. So settlement can be in terms of the deferment of their amount. That is not considered as impairment.
Okay. That's fine.
Megha ji has raised her hand. Megha Agarwal ji, please unmute yourself. Megha ji, please go ahead with your questions.
Good evening, sir.
Yeah, good evening. Yeah.
Sir, I have 2-3 questions. My first question is that, since in PPIRP, the COC has right to invite other resolution plan. So is there any concept of RFRP in PPIRP?
Okay, they have not really clarified this particular aspect, that how it is to be done. In fact, I have not been able to go to the regulations in detail because they came only yesterday. So maybe it is something is there, because invitation for, I can see that there is a regulation 43 which talks about RFRP. Yes, it is there.
Okay. Because that should be like decided well in advance.
Yes, it is there.
And sir, one more question, there is a definition of your deciding factor of significantly better. Then should it be decided well in advance in COC meetings?
Oh yes, because you are going to decide what is going to be the score. So you decide a methodology of score. They have given some illustrations also, and with those illustrations, well, one can really understand. And they are contained in Regulation 42. If you go through that, I think it will become very clear because they have given illustrations.
So it is like different from evaluation matrix.
It is a kind of an evaluation matrix only, but there is a criteria. I mean, you need not go into the illustration 1 and 2. You can have your own evaluation also. They have just given an example that this is one of the ways you can do that.
Sir, one more last question.
Yeah.
What happens if the MSME fails to implement the base resolution plan as approved by COC?
Okay. See, the consequences are definitely not mentioned here, and consequences have not been mentioned anywhere. And if they can't go for CIRP for the next 3 years because that is the bar, probably then the company is fit for liquidation. So that I'm presuming, because nothing is clear on that aspect. Again, this is a good question which actually requires clarity.
सर लेकिन यहाँ पे तो लाइक PPIRP सक्सेसफुल नहीं हुआ है ना, ये तो फेल हो गया है, तो कंपनी वो 3 इयर्स वाला जो बार है वो कैसे?
अच्छा आप no, I thought once it is approved and then fails later.
Yeah, it is approved once, then like implementation part पे fail हुआ sir.
Correct. If implementation part पे fail हुआ, so now the corporate, I mean the CIRP cannot be started within the okay. Maybe CIRP can be started by somebody else because here the corporate debtor cannot start the PPIRP process again or CIRP. So maybe any other creditor or the committee of creditors can go and start the CIRP of that company. So that could be the possibility.
Okay, thank you so much.
Yeah.
Mr. Pradeep Tyal.
Yes, sir. Good evening, sir.
Yeah, good evening. Yeah. Go ahead, sir.
Sir, can you list out some situation in which the CD would be like to going into this process? Because here only CD has been empowered to file the application. Practical situations where CD will be like to going through this process.
Well, I can give you a number of instances where the companies or MSMEs are in severe financial crisis, but they are honest. I mean, it's because of the business, something has happened to them. They want to come back, but the banks are not agreeing for OTS. So here he can offer a particular plan. They say, look, I can pay you this 50% or whatever it is, accept it. Otherwise, obviously, there's some new resolution. And then you can also find an investor also. See, the another part is because there is a stamp, there is going to be a haircut. Investors will also be ready to support you. There are a lot of investors who have got funds nowadays who will support, and maybe you'll have to dilute your own shareholding. Well, that's the answer, but you still retain your company. So I can see many companies coming for
this. Sir, but CD has always an option to find some investors out of this whole process. But what's the point in going through this process?
I'll tell you. See, if you go outside this process, then you don't get proper haircuts. You don't get, you see, other things. Here, what will happen is that the bankers are very much interested because there is a price discovery. As I'm mentioning time and again, bankers are not going for OTS because they are afraid of, you see, the investigating agencies. Today, they are not taking any calls on OTS. But here, they will be more confident because they will not be afraid of them. And then there is a price discovery also. That's the reason.
Okay.
Mr. Ravichandran,
and any investor coming, they will also have more confidence. Yes. Yes, sir. Go ahead.
Mr. Ravichandran, please. Can we take the next question? Ravichandran ji is Mr. Ravichandran, you can unmute yourself. Okay. Mr. Gokul Agarwal. Yeah,
Good
Gokul ji, please.
Good evening, sir.
Yeah, good evening.
Sir, what will be the impact of books of account?
What will be the impact of books of account means?
If there are some current assets in the balance sheet before filing the proceeding in IBC, and that are not recoverable. I mean, if there is some closing stock and that stock, physically that stock is not available, it is only book stock. So what corporate CD will do in that case?
See, CD has to file an application along with the assets and details of assets and liabilities. Obviously, we believe that he's not going to give a fake list or a wrong list or a fictitious list. So if it is not, if he's sure that they are not recoverable, then he has to write it off, or he will have to tell in the application itself that they are not recoverable. So
No,
the
in
actual
balance
picture,
sheet the stock has been shown.
sorry.
In the balance sheet, the stock has been shown. If the stock has been shown, but physically it is not available.
That means there was a fraud. So then it becomes a case of fraud, or it becomes a case of fraudulent trading. Well, they will have to give a declaration first that there is no fraudulent trading.
One more question, sir. What will be the surface impact then till the answer is comes?
See, as far as surfacey against the company is concerned, when this process starts, moratorium kicks in. So therefore, there is no surfacey against the company's assets. As far as the assets of the individuals are concerned, there is no protection.
Okay.
There is no protection.
Thank you, sir. Thank you, sir.
Mr. Ravichandran, kindly ask your question.
Sir, good evening. This is Ravichandran. Sir, regarding that PUFE transactions, whether the CDs, you know, as you said, normally they will give that there is no PUFE transaction, that declaration will be there. So, what is the RP's responsibility, sir? Suppose in case there is we find that there is a PUFE transactions later, that is number one. Number two, whether FC can they say that there is no avoidance transaction in this company, so please go ahead with the resolution plan. Can they say that? That's my second question, actually.
Okay, first question is, like I mentioned, that they have to give a declaration. But this declaration is a serious thing. I mean, you are not going to give a declaration just like that. So what you need to do is maybe get a forensic audit done even prior to submitting this proposal. So be on the safe side. If you are not getting it done and later on it is found, because it is the responsibility of the RP to find out make an opinion within 30 days, make a determination within 45 days, and file application within 60 days. Well, if that application is filed, then 54J will kick in. Your company can go into liquidation also.
Okay, that means you suggest that we go ahead with the forensic audit prior taking up this assignment.
That's what I'm saying. See, if you are an honest and a genuine person, what is the harm? Get a forensic audit report from an independent auditor, flash it to the world that you are a genuine man. I think nobody can deny you that. This is what I think is a good process.
Okay. Thank you.
Mr. Raj Kamal Saraogi. Raj bhaiya.
Yeah. Regarding the fees in the regulation today, under 14.6, there is specific provision that the terms of the appointment of the resolution professional under this regulation shall include, and they have provided the three conditions, the three situations, that fees payable for performing duties under subsection 1 of section 54B. Then another situation, fees payable to him and expenses to be incurred by him for the conducting the process. And the third situation, the fees payable by him and expenses to be incurred by him in case of the management of the corporate is vested with him under section 54J. So they have specifically given a responsibility of the COC to decide before the appointment the fees itself. And they have given one more provision that the COC has to give instruction to the CD that a special bank account is to be opened, and periodically the fees is to be transferred in that account, and the operation of the bank account will be made by the RP under the instruction of COC, and they can draw their fees periodically from that account. That way they have kept provision for the fees.
Yes. That of course, because I have not covered the entire gamut of this because the time was very limited. Yes, of course, there is a separate bank account for this purpose is there. Now, as far as the fees is concerned, which regulation you were referring to, sir? Regulation 8. Sorry?
14.6. Regulation 14.6.
Okay, 14.6. Okay. Yeah, so the terms of the appointment of the RP under this regulation shall include fee payable for him for performing duties under 54B, that is prior to. No, that is the terms of appointment. when you are being appointed, later on again it will go to COC for approval. This is not COC approval.
Yeah, that is there. That is there. That is there.
Yeah.
That is.
Yeah. So because it is
That
to
is
the
there.
extent it is ratified. Because you see, a regulation cannot override the law. Law says it has to be ratified by the COC. So that problem always arises.
I fully endorse you.
Okay, thank you for pointing this out. Yes.
Sir, we could see 9 hands are already raised. How many questions you will be going to, when you may take up, sir? Namrata ma'am is there. Like I have already unmuted her.
Well,
Namrata ma'am.
It depends
Yeah,
on.
actually, I'm Ravindra Chaturvedi. Good evening, sir. My small question that suppose RP find any pub transaction and file within 60 days the MA in NCLT. That 29AG is very clear that his ineligibility will start when the adjudicating authority pass any order.
Correct.
And definitely it will take some time to pass any order. By that time 90 days will get over.
Correct.
Still the RP should continue and file the, suppose COC approve the plan subject to his decision of 29A.
Okay.
Then whether COC should, we should file the plan or we should not file the plan.
Okay, see, there are two things. One is if you go to 29A, it says that eligibility is to be seen on the date of submission of the resolution plan.
Correct.
Now here BRP has already been filed.
Right.
And then later on the determination is made sometimes later.
Right.
So it is not on the date of the submission of the resolution plan. But your point is absolutely very valid and well taken, that supposing an order is passed later on for you see recovery of this money against the CD or the promoters, then should they be eligible under 29A? Because there is a clause which clearly says that if such an order is passed, they are not eligible. But only point is, only difficulty is because if we go back to ArcelorMittal judgment by Honorable Supreme Court, it says 29A applies on the date of submission of the plan and not later.
So that means the RP should go ahead and file the plan still because the order is not yet passed. He has found the above transaction, but it is not yet adjudicated. Hence, he can file the plan.
No, if it is not adjudicated, obviously they can file. I am saying even if adjudicated.
Yes.
Are you getting my point, sir?
Okay. Okay.
Even if it is adjudicated, but on the date of submission of the plan, it was not adjudicated.
I got it.
So one can take a technical benefit of this.
Oh, I got it. And second question, sir, whether valuation is required, IBC valuation is required.
That is required, sir. Registered values are to be appointed. They are given in the same process. Actually, there is no difference in the process.
Okay.
If you have read CIRP process, these regulations are mirror image of that. Maybe one or two are different, but otherwise they are quite similar.
Okay. Thank you.
Okay. Yes. Go ahead, sir.
Gaganji, Mr. Gagan Jawar.
Sir, I have two small questions. One is normally any restructuring process takes few years time. Normally the borrower or corporate debtor would seek time for repayment. Now, would the RP have any role during that period of, let's call it implementation?
Yeah, okay. For effective implementation, it is the duty of the adjudicating authority to see that effective implementation is provided in the plan, which may include monitoring or overseeing by the resolution professional. It is possible.
Fine. And sir, one more small question that is regarding PUFA transactions. In CIRP, we had some distinction between related and unrelated parties. And for some sections like 49 and 66, there was no look back period defined. So would a similar arrangement be there in this case also, or it is a flat 2 years time for all transactions?
Okay. Let me clarify this. As far as the sections 43 to 51 and section 66, 67, 65, 65A, which is a new section, 66A, 67A, which is a new section, well, they will continue to apply even to PPIRP.
Okay.
But only thing is that relevant period that has been changed. That is the only thing. But rest of the provisions will remain same, whether related party, unrelated party.
Okay.
So if now it is a standard period of 2 years.
Fine. Thank you, sir.
Mr. Hemant Mehta.
Yeah, Sir, my question is in respect of any waiver which has been granted during the course of PPIRP by Honorable AA. Whether there will be any impact of income tax which may have to be paid upon the waiver amount.
Okay.
Can you just comment?
Okay, sir, I am not an expert on tax matters. The fact of the matter is, this is the same problem which is there in CIRP also. So I don't think it is a new problem. Probably anyone who has faced this problem, maybe they are in a better position to answer this.
Yes, sir. Secondly, whether the CD will get the clean set concept which is there in the CIRP process also. Any liabilities, contingent liability, which are there, huge liability, security liabilities.
Okay, see, as far as the impairment to the OCs is concerned, it talks about only OCs. Now, if any liabilities other than OCs are there, well, we don't know. There is no clarity insofar as there, but I believe that there can be an impairment to their liabilities, also including financial creditors. So what has been protected is only operational creditors.
Okay, sir. Thank you very much.
Sir, there are 7 members. They have still raised their hands. So kindly grant us permission if you can go ahead and take their questions.
Yeah. Go ahead, sir. Go ahead.
Okay. Thank you, sir. Thank you. Amit Surana ji. Amit Surana ji, kindly unmute yourself.
Good evening, sir.
Yeah, good evening.
My question is, in one of the slides of your presentations, it was mentioned that even if there is a default by an MSME, then it would also get covered in the scheme. It need not necessarily be an NPA. No, does that mean that even if it is not paying for 1 day overdue, it is being covered under the word default?
Well, it is covered under CIRP also. Why do you have to be an NPA account to come under CIRP? Sir, the point is the word which is used is default. Default is defined in section 3, subsection 12. What do you mean by default? 4 ingredients. There must be a debt which must be due and payable and which remains unpaid. So if these 4 conditions are satisfied, there is a default, whether one single day, whether one single rupee. Of course, it has to cross that minimum benchmark of 10 lakh rupees.
Right.
Okay.
Mr. Rajendra Agarwal ji. Mr. Rajendra Agarwal. Mr. Agarwal, please go ahead with your questions. Okay, Mr. Mugundan Thirumalai.
Yes, sir. Yes, sir. Thanks for allowing me. Sir, my question is about consideration of alternative plans.
Not audible, sir.
I have unmuted. Can you hear me, sir?
Yeah.
Go ahead, sir.
When the alternative plan is considered by the COC, not the base resolution plan given by the CD.
Right.
In such case, the other securities that the financial creditors might be having, like corporate, bank guarantee, personal guarantee, and all, would they automatically be extinguished, or how does it work? There has to be a separate arrangement.
No, they will not be automatically extinguished. So they will be similar to what we have in CIRP. In CIRP also somebody else submits the plan, but it does not protect the guarantees or personal guarantees or collaterals given by the promoters. So same state of affairs will be there. But it will be, therefore, it is in their best interest to give the best plan so that their plan is approved and they are, out of the clutches of the bankers and other things.
Okay. Thank you, sir. Thank you.
CA Lalit Sir.
Sir, it's good to see you once again because you are my tutor on 38th batch. You are in USA at 1:30. You gave a lecture, sir.
Right. Okay.
You are stuck up in US. Sir, I want to know, will it not be a good tool for CD to use it as to reduce the debts?
Yes. You see, the point is in India, particularly MSMEs, they are all promoter controlled, isn't it?
Yes.
Who wants to lose his company? Nobody wants to lose his company.
Yeah.
Or this is the best thing. If you are a genuine promoter, definitely you are going to make use of it. This is one of the best schemes which I can think of.
But they may take a undue advantage also. No? Some may.
It doesn't matter, sir. So far as the banks are getting their money, if somebody takes an undue advantage, it doesn't matter.
So there will be a shift of management.
See, the first attempt should be that there should not be any shift of management. But if you are impairing operational creditors, then there will be a change of management.
Okay. Mr. Rajesh Jasti.
Hi, sir. This is Rajesh Jasti. I have two questions, sir. And the first question is, once the PPIRP, if the application is admitted, so can we apply the same section 12A where application can be withdrawn with a majority of any specific percentage, like 90% in the case of CIRP? In PPIRP, can we withdraw the application?
Well, right now there is no provision which talks about withdrawal, and Section 12A has not been made applicable to this process. So I'm really doubtful whether such an application can be allowed to be withdrawn once it is filed. But supposing at the end of the day, because this application is filed by CD, if CD does not submit any BRP or it does not come out with a better plan, well, that's the end of the matter. Then 90 days, nothing comes out, automatically this process will be terminated.
Okay, that's all. Thank you, sir. And one more question, sir. See, the CD has to submit BRP, that is basic plan, and later later if CC come up with another alternative plan which was significantly better than the PRP. Okay, but intentionally because in the PPIRP process, all the management rests with the CD, right? Corporate data, not with the only monitoring part will be taken care by the RP. Okay, so any scenario where if intentionally CC corporate committee of creditors, okay, rejected the alternative plan, even though it is significantly better than the BRP. So what is the responsibility on the part of the RP? Can he approach the adjudicating authority? Can he communicate to the adjudicating authority saying that what is his responsibility here?
Kindly unmute yourself.
Yeah.
I muted all. Huh?
Yeah. Okay. See, in fact, I've forgotten the question also, what he asked the question. So maybe you'll have to unmute that fellow once again, because I could not really understand his question.
Okay.
Anyway, we can go to somebody else if that is there.
Mr. Sanket Deshpande.
Yeah. Hi, Sanket.
Hello, sir. How are you?
I'm good.
I'm good, sir. Thank you.
Yeah.
Absolute pleasure listening to you, sir, yesterday and today, and looking forward to hear more.
Right. Go ahead.
So I have three questions basically. One is regarding, sir, base resolution plans to be submitted in 2 days.
Right.
So how far practical is it, submission of the base resolution plan in 2 days?
Okay.
And then
let me answer this question one by one. See, as far as BRP is concerned, Sanket, let us understand this process doesn't start on that date. The process is already in informal discussion, right? You are already in informal discussion with the bank that I'm going to go ahead with this. So please appoint the IRP also. He submits his report. So in the meantime, you get sufficient time to prepare BRP. Okay, because 2 days is from the date of admission.
Right.
But the prior process will consume maybe 30 days. So you have sufficient time.
Okay. Yeah. Okay. So secondly, if the entire basis of the pre-packs is on, say, Swiss challenge, and what also we heard Mr. Sahu on the other day. So, and in this case, the corporator is not given chance to or opportunity to betterment of his resolution plan to the one if from the other resolution applicants, if reasonably better, which is found. So, and typically in Swiss challenges, you would find that the proposer who gives that concept, I mean, he also has at the end of the day opportunity to better the other offers. So,
okay,
I think in this case, this is not there.
Okay. Sanket, if you heard me carefully, I mentioned that the significantly better plan will be taken out, and then they will be competing with each other. So even the BRP will compete with that.
Okay, so still he will have opportunity to better that other plan?
Yes.
Okay. And sir, thirdly, if this process doesn't get ahead and either liquidation doesn't happen, and if it's back to square one, then whether there is again a route of Section 10 open to the erstwhile promoters, or is it there's no route of Section 10 again
No,
Ideally, it should not be there, right?
yeah, it is not there. That is why they say cooling off period for 3 years.
Okay.
You can't file CIRP, you can't file PPIRP. And
Okay, sir.
you see, to answer your previous question correctly, let me give you you see this thing. If the plan is significantly better, then there is no competition.
Right.
If the selected plan is not significantly better, supposing you say it should be better by 20%, then there is no question of any Swiss challenge. But if it is better, say only by 10%, then they will compete with each other. That's the proposal.
Thank you.
Okay. Yeah. Sir, you are also muted. Yeah.
Yeah. Unati Nandalaskar. Madam Unati, you have been unmuted. You need to unmute yourself. Yeah.
Yes. Good evening, sir.
Yeah, good evening.
So I had a question wherein there is, for example, if it is a class of creditors and the base resolution plan is not working, and we call for plans from pre-RAs. So can we appoint a process advisor at this stage? So,
okay. See, as far as the process, appointing of process advisors and other, I believe the process will remain the same. There's not going to be a big change in what we have been doing, but only thing is here the idea is to keep the cost to the minimum. Because, because we believe these are medium and small scale industries, so large plans are not there. So that means they can be handled even without process advisors. So generally you require process advisors in large plans.
yeah, but when it is a case of class of creditors wherein home buyers are involved, which is 250 crores or more than that for the debt purpose, I am saying. So in that case, can a process advisor be appointed so as to bring developers or builders in place?
Definitely you can do that. Definitely, because it is the prerogative of the COC to take call.
COC.
Yeah.
Yes. So we can put that in the engagement letter or the mandate, which is to be discussed with the COC at the early stage.
Absolutely. Absolutely. You can do that.
And sir, one request that earlier someone had asked a question with respect to 29AG. Can you just repeat the answer? Because what if an order is passed against the director or promoter in case of an avoidance transaction? Then what would happen to the case?
Okay, seriously speaking, I am of the firm believer that if any order is passed, that person should be disqualified. But having said that, we have to go by the jurisprudence. The jurisprudence says that the eligibility of a resolution applicant is seen on the date of submission of the plan and not later. So if BRP has already been submitted, he was eligible on that date. The order came later, so therefore it will not matter.
Okay. What if the order comes first then?
No, it can't come, no, because you see the application will be filed within 60 days. By that time, BRA is or BRP is to be submitted within 2 days.
2 days, correct. Yeah. Correct. Okay. Noted.
Yeah.
Mr. Pratim Bayal.
Sir, good evening. I just had one more question.
Yeah.
Sir, what about the statutory dues? Because they come also under operational creditor. Now, MSME, it is very practical that sometimes they have huge tax liabilities and they just want to get that out of it. So there, and there is no impairment provision in this case. So what is the position of statutory liability? And so is there any respite of CD?
Okay. See, the point is, number one, if there is an impairment, number one, there can't be any impairment. Second, if there is an impairment, then there has to be a change in the management. Now, if there is no change in the management, then an adjudicating authority has to put it in liquidation. So these are the conditions. Okay. So
with this, we have actually surpassed, as an organizer, we have surpassed our time of 5:30. It is now 5:42, and we are really grateful to you. You took all the questions from all the delegates who has joined. This is a wonderful session, very candid, and in such a short span of time, you have covered the entire topic of this MSME IBC particularly. So hats off to you, sir. Hats off to you and all our delegates. I hope and I believe must have been benefited with this. May I request our Vice President, Anu Banka, please offer a formal vote of thanks to the sir. Anup, please offer a formal vote of thanks.
Thank you, Anup. Respected President, our most valuable invited guest speaker, Mr. Ashish Makhija ji, ladies and gentlemen, good evening to all of you. Thank you, each one of you, for being here with us today. It is my privilege to propose a hearty vote of thanks on behalf of ACAE. First of all, I would like to propose hearty vote of thanks to our respected guest speaker, Sri Ashish Makhija ji, for gracing today's seminar. I'd also like to express my profound gratitude to our guest speaker for his excellent deliberation and sharing with us his valuable thoughts and opinion today and making this seminar interactive and meaningful. Thank you, sir, for your excellent and thought-provoking address, sir. Now I want to share, as a token of love and affection, a e-memento to our guest speaker. Anup, can you share, please? Thank you, sir.
Yeah, thank you.
Thank
you, sir. Thank you so much.
Now I thank to all participants who have participated in large number and making this seminar a great success. You always help us by your presence to carry out this kind of seminar. Thank you once again to all of you. Thank you, sir.
Thank you.
Thanks, sir. Thanks for joining and deliberating our learned audience, and you have shared your time, sir, with us. It is really a thoughtful deliberation, sir.
Thank you. Thanks for inviting me. Thank you so much.
Thanks, sir. So with this, we close this session over here.